Hi, I'm firearms attorney Gilbert Ambler, and a couple of weeks ago I did a video talking about the DOJ process to restore gun rights, which had been announced. And it was very exciting because it's the opening of a door for a federal gun rights restoration process that has been off the table, frankly, since 1992, and is going to help a lot of people get their rights back. However, in the video I did, and I acknowledged this in the video, there were limitations that I can't really address. And those limitations are the question of even if you get your federal rights restored through this process, is whatever state I live in going to recognize that federal restoration? And I will tell you right now that I can't fix that problem. I can't fix it entirely because I'm not licensed everywhere. And even in the states I am licensed in, I can't tell you with certainty whether it's going to be recognized because there is some nuance. But what we have done is we have gone through, and I've done some research, and I've tried to find the appropriate statutes for all 50 states. And I've gone through all 50 states, and we will go through in this video all 50 states to try to present our best guess at whether the federal restoration will be effective or be recognized in each and every individual state. And again, obviously I'm not licensed in all 50 states. This video is not intended to be legal advice. If you want legal advice, you should talk to a competent firearms attorney in your state to get actual legal advice on whether a federal restoration would be effective for you. And of course, we had lots of people that actually subscribed to our channel based on that last video, which we appreciate. As always, if you have not yet done so already, go ahead, give us a subscribe, like, comment with your thoughts, and share with your friends. We also had lots of people that contacted our office, Ambler Law Offices, and we probably can help many of those folks obtain a federal gun rights restoration. And frankly, I have to thank my outstanding staff who handled a ton of calls based off that last video we did. But again, this video is to go through, and what we're going to do is we're going to go through it alphabetically on each state and try to give you our best predictor of whether the federal restoration will be recognized. And we sort of group the states into different categories. There are some states out there that explicitly recognize a 925C restoration. There are some states that recognize a civil rights restoration. There's some states that don't have a prohibition, their own prohibition on felons or misdemeanor crimes of domestic violence or certain categories possessing firearms in the first place. And then there are states that are going to either require their own process on top of the federal restoration, something like a pardon or an expungement. And finally, the worst of the worst, there's going to be some states that probably aren't going to be able to help you or provide a path to state gun rights restoration, period. Meaning there's probably going to be some states where even if you get your federal gun rights back, it is always going to be a crime in that state for you to possess firearms. And quick reminder, there's these classifications of crimes. Any crime that is punishable by over 1 year if it's a felony, over 2 years if it is a state-based misdemeanor, and that is the max possible punishment that can be received, not the punishment you actually received, and then misdemeanor crimes of domestic violence. There's several other categories, dishonorable discharges, etc., that affect gun rights. But those are the big ones under federal law, 18 U.S.C. 922G, that we're looking at and that the Fed has now opened a path towards restoration for. Let's kick it off. And we're going in alphabetical order so you can fast forwards to the states you're interested in. And I am unfortunately going to have to read this to you again. All right. So, and one final disclaimer before we dive into this. I have to actually thank two websites that were very useful in doing this research. The first was the Restoration of Rights Project, which had a lot of these statutes, not all of them, but a lot of them. And then probably the only time you're going to hear me say this, but I had to thank the Giffords Group, because the Giffords Group, for all of their anti-gun motivations, has a pretty good website that provides a lot of insight and information into prohibited persons on a state-by-state basis. All right, here we go. So Alabama. I think Alabama is probably a yes. You are not considered convicted in Alabama if you had a civil rights restoration. I'm looking at Alabama statute 13A-11-72 H1B. Alaska's going to be a maybe, I think. Looking at Alaska statute 11.61.200, There's no specific procedure here for Alaska to restore rights, but Alaska appears to only criminalize handguns for people that have been convicted for certain crimes, and only for 10 years from release of supervision for most other weapons. And there's going to be an affirmative defense if it's been more than 10 years since you're released from conviction or supervision. Arizona. Probably not a process right now in Arizona to recognize the federal restoration statute, but they do apparently have a specific path to obtain a state pardon. Arkansas, probably going to be a yes here. The prohibition on firearms does not apply if you have been authorized by and subject to such conditions as prescribed by the governor or his or her designee, or the United States Bureau of Alcohol, Tobacco, Firearms, and Explosives, or other bureau or office designated by the United States Department of Justice. And so that law is, fortunately, because it's not specific to ATF, it includes anyone authorized by the Department of Justice, which is how we're doing these restorations at the federal level at this point. Arkansas is probably going to recognize. California, should not come as a shock to you. California is probably not going to recognize it. Check out California Penal Statute 12021, subsection A. Connecticut, another notoriously anti-gun friendly state. Again, probably not. Connecticut General Statute 53A-217. Delaware, probably not going to recognize the federal restoration if you've been convicted of a felony, might recognize it if you've been convicted of a misdemeanor after 5 years. I'm looking at 11 Delaware Code, section 1448D. Florida, probably will recognize if your civil rights are also restored. Keep in mind this is civil rights plural. There's been some case law in the past saying a restoration in certain jurisdictions, saying a restoration of the right to possess firearms is not a restoration of civil rights plural, because they're not restoring other rights like your right to vote and right to hold office at the same time. So watch out for that nuance. But probably. Again, we're looking at Florida Statute 790.23, subsection 2. This section shall not apply to a person convicted of a felony whose civil rights and firearms authority have been restored. Georgia probably will recognize the federal restoration, but only if you also receive relief in Georgia. Looking at OCGA 16-11-131D, which appears to allow you to petition for relief in Georgia if you have 925C relief. Hawaii, again, not gun friendly and probably not going to recognize this. Looking at Hawaii Revised Statute section 134-7H, unless it is a misdemeanor that prohibits you and you are no longer prohibited by 18 U.S.C. 922. And again, that would be somebody who's been convicted of a misdemeanor that affects you under 922, but has received a restoration under Section 925, and 20 years have passed from the date of conviction. Idaho, probably not. Idaho seems generally very strong on firearms and appears to, at least at the state level, automatically restore gun rights upon release for most convictions, but they expressly recognize civil rights restorations from other states only where it was the convicting jurisdiction who restored the rights. So Idaho Code, this is 18-3316, subsection 3. What this means is if you had a felony in Idaho or a prohibiting misdemeanor in Idaho, the federal restoration combined with Idaho's automatic restoration would probably help you. But if you move to Idaho having been convicted in another state, let's say you were convicted in California, the 925C restoration probably does not help you because the convicting jurisdiction is not the one restoring rights. Illinois, again, no surprise here, probably not, but it might open up the ability to apply for state relief. And I'm looking at 430 Illinois Consolidated Statutes, ILCS, I guess, 65-10A, 10C3. And so opening up a possibility to apply for relief if it has been at least 20 years, and I'm looking at subsection C4, relief is not contrary to federal law. And of course, if you already have a federal gun rights restoration, you would be arguing that your relief in Illinois is not contrary to federal law. Indiana, probably going to be recognized for most felons, and there's an exclusion for serious violent felons, which I guess is statutorily defined in Indiana. But for most felons in Indiana, there is not a specific state level prohibitor. So not a specific state level crime that I could find prohibiting you from possessing firearms. Now, you still, unless you get the federal restoration, would still be prohibited federally, but that means if you receive a federal restoration without a specific state level crime in Indiana, I think you're probably good to go. Iowa, probably going to be good to go in Iowa as well. Looking at Iowa Code Section 724.271B, which allows for firearms possession if civil rights are restored. Kansas, going to probably be recognized the federal restoration for most felons. Kansas Statute 21-6304 relieves state felonies of most sorts after either 3 or 8 years. So in Kansas, most prohibiting crimes you're going to be relieved from after either 3 or 8 years. And then once the federal prohibition is lifted, assuming you get your federal rights restored, you would have neither state or federal prohibition at that point. Louisiana, probably, again, they seem to restore most rights after 10 years at the state level. So if you get the federal restoration and wait 10 years in Louisiana, you would presumably be good under both. Looking at Louisiana RS 14:95.1C. Maine, probably not in Maine. Maine revised statute Title 15, Section 393 does not look good for the restoration of rights. Maryland. Ironically, Maryland, not typically pro-gun, but Maryland is pretty friendly if you obtain a Maryland expungement on top of the federal restoration. Here's where things get interesting. Maryland has a process for expungement right now. You can expunge things. The statute's pretty poor on it. I'm looking at Public Safety 5-101 in Maryland. Now, Maryland State Police, I know, have taken the position in the past that a Maryland expungement restores your gun rights. This is interesting because the federal government has taken the opposite position and has said Maryland expungements don't restore gun rights because we can still, in certain scenarios, see record of the conviction, so it's not a true expungement. What does that mean? It means if you get a Maryland expungement, which Maryland State Police has said clears gun rights, and you get federal restoration under 925C, in theory, you would not have a state or federal prohibitor in Maryland. Massachusetts, it depends. I'm looking at Massachusetts General Statutes, Chapter 140, Sections 129B2. For a federal felony, if it has been 5 years from release, the answer is probably yes. A federal restoration would restore your rights in Massachusetts. If you have a state conviction from a state other than Massachusetts, probably not, since the law says, and the applicant's right or ability to possess a rifle or shotgun has been fully restored in the jurisdiction where the conviction or adjudication was entered, then the conviction or adjudication shall not disqualify such applicant for a firearms identification card in Massachusetts. So again, state-based felony or misdemeanor conviction outside of Massachusetts, probably the federal restoration does not help you in Massachusetts. Federal felony, and it's been at least 5 years, federal restoration probably does help you in Massachusetts. Michigan, the federal restoration is probably effective for most felons after 3 years, or for misdemeanors who have been convicted of domestic violence-related misdemeanors after 8 years. I'm looking at Michigan Statute 750.224F. Minnesota. Yes, Minnesota will recognize probably, again, I'm not licensed there, can't give you specific legal advice, but Minnesota will probably recognize the 925C restoration. Minnesota Statute 609.165 specifically references 925C. Likewise, Mississippi looks like they are also going to probably specifically recognize the 925C federal restoration. Looking at Mississippi Code 97-37-5, subsection 1. Missouri probably not going to recognize the federal restoration, ironically, but expungement appears to be possible in Missouri. I'm looking at Missouri Revised Statutes, section 610.140. Montana. It depends on the offense that you were convicted of and what's prohibiting you under Montana law. Montana Code Section 45-8-313 appears to only ban firearms at the state level if you were convicted of an offense either involving a dangerous weapon or were convicted of a felony involving sexual violence. So if you were convicted of other sorts of felonies or misdemeanor crimes that would otherwise affect you under federal law, then the federal restoration would probably restore your rights because there would not be a state level prohibitor. Nebraska, probably not. Looking at Nebraska Revised Statute Section 28-1206. Nevada, also probably not. I'm looking at Nevada Revised Statutes 202.360, which prohibits possession unless pardoned if you have been convicted of a prohibiting offense. New Hampshire, also probably not. Looking at New Hampshire Revised Statute Section 159:3, which appears to, but it is important to note that in New Hampshire, rights appear to be lost only if you are convicted of certain felonies, meaning there are certain things you could have been convicted of that would prohibit you under federal law, not under state law in New Hampshire, and for those convictions, a federal restoration would probably help you. New Jersey, probably not for most convictions. Looking at New Jersey Statute 2C:39-7. New Mexico probably will be recognized. New Mexico seems at the state level to clear rights for most felons after 10 years. Looking at New Mexico Statute 30-7-16, subsection A. So, of course, if you have been cleared at the state level and the feds restore your rights, then you would have both the state right in New Mexico and the federal right. New York, probably not. New York 265.01 splits up the type of crime by what type of weapon somebody possesses. It does appear that it might be possible in New York to obtain a state-based restoration. All right, moving on. Let's talk about North Carolina. North Carolina is probably a yes for federal felony restorations or misdemeanor crime of domestic violence restorations, although federal restorations from a state felony that happened outside of North Carolina will probably not be recognized. For federal felony restorations, they will also probably need to subsequently go through a North Carolina process. I'm looking at North Carolina Statute 14-415.4. North Dakota, probably a yes for felonies. And now, felonies involving violence or intimidation are restored at the state level after 10 years. Other felonies or misdemeanors involving violence or intimidation are restored after 5 years at state level. So again, if the state's cleared you and then you get a 925C federal restoration, you'd be good to go under both state and federal law. Ohio, probably yes, in combination with a successful application to an Ohio court under Ohio Section 2923.14. Oklahoma. Although Oklahoma is a traditionally gun-friendly state, probably not for felons. Looking at 21 Oklahoma Statute Section 1283, which requires a pardon from the proper authority. And of course, this is not a pardon. Oregon, probably yes. Oregon Revised Statute Section 166.270B specifically mentions a 925C federal restoration. Pennsylvania. This is one of the jurisdictions I am licensed to practice in. The answer is probably yes in Pennsylvania, provided that you, if an 18 Pennsylvania Consolidated Statute Section 6105 prohibitor also applies to you, that you go through and obtain the state level restoration through the Court of Common Pleas. The reason I say probably yes is Pennsylvania's got a dated statute, the 6105 Restoration Statute, specifically talks about the Secretary of Treasury restoring your rights. Now, ATF was at one time under the Secretary of Treasury, but now ATF is no longer under the Secretary of Treasury, and ATF no longer has authority to do these restorations. So Pennsylvania, I think, will probably recognize it, but there is a legal issue here that their statute is talking about you first obtaining restoration by the Secretary of Treasury, and that's not how things get done anymore. Rhode Island, probably not if your conviction was for a crime of violence. We're looking at Rhode Island General Laws 11-47-5. South Carolina, probably yes, unless you were convicted of a crime of violence. I'm looking at South Carolina 16-23-30 and South Carolina 16-23-10, which defines crime of violence to mean murder, manslaughter, rape, mayhem, kidnapping, burglary, robbery, housebreaking, assault with intent to kill, attempt to commit rape or rob, assault with a dangerous weapon, or assault with intent to commit any offense punishable by imprisonment for more than 1 year. So if you were convicted of one of those, you're probably out of luck in South Carolina. South Dakota, probably yes. Rights are typically restored in South Dakota 15 years from the date of conviction or release. Again, state level would clear you. Then federally, you could restore your rights through 925C. Looking at South Dakota 22-14-15. Tennessee has a very complicated statute. I think my answer is probably not, at least for carrying weapons, not going to have your rights restored. Also, probably not for possession if you were convicted of a felony crime of violence, an attempt to commit a felony crime of violence, or a felony involving the use of a deadly weapon, or a felony drug offense. This is Tennessee Code 39-17-1307B1. For other types of felonies or misdemeanors, I think that a federal restoration would at least clear your ability in Tennessee, probably, to possess the firearms in your home. Texas probably will be recognized for felons if it has been at least 5 years from the date of conviction or release from supervision, whichever is later, and if the weapon is possessed only in the home, or if you were convicted of a misdemeanor crime of domestic violence, if it's at least 5 years from the date of conviction or release from supervision. Texas Penal Code 46.04a. Utah probably will recognize a federal restoration if you were convicted of a federal felony, not if you were convicted of a state felony in other jurisdictions. Utah Code 76-10-503 1CIB, which restores rights if your civil rights have been restored by the law of the convicting jurisdiction. That's why I say federally, probably would recognize a federal restoration for a federal felony. Vermont, probably yes. We're looking at 13 VSA Section 4017, which specifically exempts those with 925C relief. Moving on to Virginia, another state that I regularly practice in, and the answer is possibly in Virginia. We're looking at 18.2-308.2B subsection 4, which restores the right of your ability to possess firearms in Virginia if you have a rights restoration from any other state that does not specifically limit your ability to possess firearms. Now, I've previously litigated this issue in Virginia successfully on behalf of clients and argued it would reach or create an absurd result if you could have a gun rights restoration recognized by Virginia for literally any other state. Got convicted in Idaho, New Mexico, Nebraska. Virginia would recognize any of those restorations, but not a federal restoration. So I've previously prevailed on an argument that would be an absurd result. Hopefully we can prevail on that argument again in the future. There's a bit more nuance to it. We also argued that the term state under Virginia law should be construed to mean a political body of people like the United States. Washington, probably not going to recognize the federal restoration, although Washington might have a separate procedure that could be used looking at RCW 9.41-041. West Virginia, probably yes, if coupled with a separate petition under West Virginia law that is also granted. This is West Virginia Code 61-7-7F, which says that you can petition and bring such an action in West Virginia if such action would not be prohibited by federal law. So again, you get the federal relief, and then I think you could petition in West Virginia. Wisconsin, probably going to recognize the federal restoration. This is Wisconsin Statute 941.295B, which specifically references 925C restoration. And then finally, Wyoming, probably not unless relief is also obtained under Wyoming law. I'm looking at Wyoming Statute 7-13-105. If you have made it to the end of that list and listened to all of these states, well, thank you for paying attention and caring about this. Many of you probably are fast forwarding back and forth to find specific states that matter to you, and totally understand that as well. If you have questions about the federal restoration process, feel free to contact our office. As always, until next time.